Speakers today are James Bowling. James is a barrister at Four Pump Court, one of the leading senior juniors at the well-known commercial set. He was awarded Construction Junior of the Year at the Chambers Awards in 2017, and James has been described as an excellent all-round strategist and advocate. He's persistent, articulate, and well-prepared, and clients say his knowledge of construction law is encyclopedic. So hopefully we might not have time to go through the full encyclopedia today in the next 30 minutes, but we'll hopefully draw on a little bit of that in the next session. So Beth Kalischer is an experienced corporate solicitor with particular experience in reorganisation, restructuring and refinancing transactions as a result of insolvency. Her work covers a range of sectors at the firm Womble Bond Dickinson, where she's worked since 2014, and David Birne is an insolvency and restructuring practitioner with over 25 years of experience. He works with Opus Restructuring, helps clients deal with financial issues from corporate restructuring and turnaround through to insolvency. Opus has got offices throughout the UK with 15 partners, including David, and the firm supports businesses across all sectors and services. So today we're going to have a look, as I say, at the thorny issue of insolvency and the law. We're going to hopefully take a look at some recent case law as well. There's quite a lot of discussion around insolvent companies and adjudication and all sorts of things in the world of construction at the moment. And we're going to identify some of the options that are open to firms that find themselves, and I learnt a new word while we were researching this. This is not an area I know much about, so I learnt the word impecunious while reading James's paper for the SCL earlier in the week, so that's a new word to me. So David, while we're on the subject of impecunious companies, what is insolvency? Starting right at the beginning, and if businesses face financial difficulties, what are their options?
Well, in order to consider the options available, we actually need to start with a definition of insolvency. And I must make an initial apology of bringing a section number in so early in the webinar, but section 123 of the Insolvency Act states that the company is either unable to pay its debts as they fall due or balance sheet insolvent, so liabilities exceed the assets. So claims against the company and its directors derive from the date of insolvency. So the question is the business, the company, the LLP, the partnership, insolvent? And the government have acknowledged the sudden and drastic effect of COVID on the definition of insolvency. There is no liability of a director for wrongful trading to the 30th of September, which has just been extended to the 31st of December. But does this mean the directors are safe from blame? James will comment more on this in detail, but it's not a get out of jail free card. So directors do need to take advice, because there are potentially other claims against them as a result of insolvency. Importantly, it is not the end of the business if it is insolvent. The Companies Act, the Insolvency Act in particular, provides a whole tool cabinet of options. Liquidation and winding up of the business are not the only options. The goal of a business recovery professional is to provide the owner and the director with options and the pros and cons of each route. One route is administration. Normally, this is there to save part of the trading business by selling assets and maintaining the trade. The administration pre-pack is regularly in the press, with Coke Brasserie, the most recent that was earlier in the week. Pre-pack is essentially a sale of the business which is negotiated before the formal appointment of an administrator and then completed immediately following the appointment. There is a continuity of supply and trade, and that is why it is so desirable. This process generally results in the saving of jobs, allows trade to continue, and enables asset values such as debtors to be maximised and breach of contract claims, which are creditors, to be minimised. There is, from July 2020, a new option called a moratorium. Directors stay in control with the insolvency practitioner as a monitor. So this lasts for a period of 20 days, which can be extended, but there's always the possibility of rescuing the company as a going concern. This is new, so is untested. James will also have to talk about this further. Now, company voluntary arrangement, very briefly, that's essentially a deal with its creditors. So if the company is insolvent, this can be the right route to be used. You need 75% of the unsecured creditors, and that doesn't include the banks, to vote in favour. The advantage is It offers a deal over a number of years, normally a 5-year period, of which you have to pay monies into a pot for the benefit of creditors. It keeps the business going in its entirety and uses debtors you can use debtors to fund the business, and you can actually do restructuring by way of redundancies, which may be necessary to make the business profitable. There's no new company is set up, and it's actually seen as an honourable way of dealing with its creditors, but you're tied in for potentially up to 5 years, so directors may find that undesirable, and there is an effect on the credit that's obtained. So cash flow is extremely important, and understanding working capital requirements is one of the most important things to do with regard to a voluntary arrangement. A liquidation is really the last resort, but you are still able to buy back assets if the price is right and take on staff into a new company. But think carefully about a new business model. Is it viable? The business before has not survived, possibly because of COVID, but the question is the new business model viable? Simply, if you're not insolvent, there are lots of options. Debt management, turnaround options. Again, seeking the advice of a professional is essential to assist with these. Maybe cash flow management, restructuring, which may include redundancies. Sometimes increasing margins may help. Changing the type of work, for instance, by dropping some less profitable work, reducing stock levels can help as well. But the issue is many projects within the construction industry are medium to long term, so it's hard to vary costs. But be very careful when speaking to your clients and even your suppliers. I've seen cases where directors ask their client for early payment due to cash flow difficulties, thinking that they will be helped, but the client does the opposite and holds back payment as they're retaining funds to help get someone else to finish off the work as they're expecting failure. Therefore, tactical advice is essential and is always needed in these cases.
Brilliant, thanks, David. David and I are in a networking group together, and he always comes along and regales us with all kinds of fascinating stories of what he's been doing in the world of insolvency. So let's get some real useful insight from David. Beth, if I can come to you, often I think people look at lawyers as the bad guys in these situations, and just coming in to mop up the mess and clear things up when it's all too late. Is that a correct perception? How do you help people out in companies out in their hour of need?
Yeah, no, and I think clearly I'm biased, but that's absolutely not the case. And I think lawyers don't just come in at the end and mop things up regardless of the perception. And I think the key point here is to instruct early. Because the sooner you get advice, the more options are likely to be available to you, and that includes advice from an IP as well, such as David. And I think one of the key points to flag is that when a company is insolvent or is likely to go insolvent, the duties of the company's directors, broadly speaking, shift from the company's shareholders to the company's creditors as a whole. And appreciating David's mentioned this, and James is going to speak about it later, but the directors can actually be personally liable, and so where we can help is advise on that liability and assist in avoiding any personal liability for the company, and by attending board meetings and assisting in documenting decisions, so there's a clear paper trail of why a particular course of action has been taken. And along with IPs, we can help explore options available for the companies, and David's listed a lot of the different insolvency procedures, and clearly just the sooner advice is taken, the more options are likely to be available. And I think as David's mentioned as well, I think there's a perception that if a company is insolvent, then liquidation is the only option, and it just basically straight to liquidation. But generally speaking, that's often not the best course of action. So we can help assess options, and it might actually be better and result in a better outcome for creditors if a company continues to trade. So I suppose my overriding answer is seek advice as soon as you possibly can, and we can assess options and take it from there.
Brilliant. And so looking at that, what if you're involved or a company is involved in contracting or part of the contract, what warning signs should people look out for in the supply chain? Is there anything that they can do to mitigate against the risk of other businesses or their own business becoming insolvent or running out of money? Is that something that you give advice on? Do you have any tips?
Yeah, I mean, there's a number of warning signs that a company's facing financial difficulties, and some of those are more obvious than others, but can include things like, any obvious cash flow issues, is a company paying invoices late or not paying them at all? Are they not paying their staff? And if a party comes back, during the term of the contract to try and renegotiate payment terms or other terms of the contract, and then more broadly speaking, it's always useful to keep an eye on company's house to see if anything has been filed there, or if accounts are filed late, which can often be a red flag. And also, of course, if a winding up petition has been presented against the company, and we can assist in monitoring that. There's searches we can do to see if any action has been taken against the company. And in terms of mitigating those risks, I think a key point is, before entering into a contract, it's important to carry out financial diligence on the other party. And then any issues that arise then, A, know what you can get into, and B, you might be able to deal with them in the contract, or if what's found is so fatal, you don't have to contract at all. Other options to mitigate risk in terms of insolvency, you could look to take a parent company guarantee from a contractor's parent. So then you've got recourse from the parent if the contractor themselves doesn't perform. Another option is project bank accounts or escrow accounts, so that the money that's allocated to the contract can be put into that account, and then that's protected. Equally, you can also put different provisions in the contract to protect your position. Obviously, this will depend on the relative bargaining power and the commercial relationship between the parties, but you could try and reduce payment periods, potentially, to reduce the financial exposure. You could ask for advance payments on larger items. It might be worth trying to include, obviously depending who you are, retention of title clauses. They need to be properly drafted and incorporated into the contract, but they can allow a party to get back goods or materials that and it's not been paid for. And I think a key point to mention is an option previously would have been to terminate the contract on insolvency. But one of the key changes for the construction sector of the Corporate Insolvency and Governance Act that came into force in June is that, broadly speaking, it prevents a supplier from terminating a contract if the other party enters into insolvency proceedings, which clearly is taking away a remedy. But a potential way to mitigate this is to include termination rights in the contract that allow for early termination that would be triggered before insolvency proceedings are commenced. And again, it's just a case of monitoring this during the term of the contract quite carefully. And if any issues arise, checking what your termination rights are and whether there's any that you can exercise prior to insolvency. Otherwise, this new prohibition will apply. So, I'm perhaps labouring the point, but I guess the key point is to keep out for any warning signs and take advice as soon as you possibly can.
Brilliant, thanks. I should add at this point that there are some questions coming in. Do drop your questions in if you wish as we're talking, and we'll come back to them at the end if hopefully we'll have time to answer, so long as there's not too many. David, did you want to add anything on to Beth's warning signs there and tips there, or has she pretty much covered everything that we can think of?
Beth's done very well to cover most of the items there. I think on the practical side, one thing which I have seen in my years of doing insolvency related work is a position, particularly in construction, we're taking on jobs that are perhaps on the larger side for the contractor, maybe much larger than they normally would do, and I've seen that as a problem in a number of cases I've dealt with. So the cash flow effect of taking on a very large project may be underestimated, leading to cash problems quite early on in the project. And I've seen even a case where it appeared to be the goal of the main contractor to push the subcontractor towards insolvency in order to hold cash back and make some profits themselves. So looking at it on a sort of practical level, you've got to be really careful. And I think one of the things that is very important is to stay in contact and hopefully stay on good terms with your client, be it the contractor or subcontractor in that particular case. Another just one other warning point was I've seen cases where offshore companies have been used as the client or the contractor. And the problem there is very difficult for you or for a company to sue that offshore company if there's any sort of breach of contract.
And on the subject of construction insolvency, and we had a little chat about a week ago, and you were talking about the complex web of construction contracts and things like that. Is that something that you come across quite a lot, and what do people do about those kind of the particular complexities of construction insolvency?
Yeah, and there are certainly common issues there. I've worked with groundwork companies, mechanical engineering businesses, with local council contracts, large residential contractors. Non-payment at crucial times of the project is what I've seen. And I say crucial times, so there's particular points where maybe large items are being delivered. That's always been an issue which I've been aware of. So use of offshore companies, which I mentioned, you can't sue them. I mean, significant variations and tough contract terms and tough variation terms is something I've seen as well. For instance, variations only being paid at the end of the contract, meaning that, again, very difficult cash flow for the contractor to continue working. And even what was a Ponzi scheme. So this is where a contractor is taking a job at below cost. So when you're looking at finding a subcontractor for a particular job and you're saying, well, that's a fantastic price, they may come with some pitfalls in relation to that. Have they got the cash to continue to finish the project? I think the main point is big job means, is it too good to be true? And I think, as Beth said, take guarantees if you can, because I've seen situations where they have been very useful if a project has failed.
Okay. Right, James has been sitting very patiently waiting for us to get to him. James, how do courts deal with insolvency, and have there been any notable changes recently in that arena?
Thanks, Stuart, and good morning, everyone. I noticed that both David and Beth have set me up beautifully by pushing off anything that they didn't want to deal with to me coming last. The first three cases I did at the bar were a construction dispute, a claim on a guarantee given by a director, and then a presentation of a winding up petition. And it's been more or less the same ever since. The construction industry is particularly vulnerable to insolvency type problems, in my experience. A lot of small to medium sized businesses, a lot of their equity is in their debt book of debts, a tendency, as David says, to scale up the business via subcontracting quite quickly without the management to match. So construction and insolvency tend in my experience to go hand in hand. And if you'd asked me the question that you just asked me 8 or 9 months ago, the answers would have been very simple, and David's outlined most of them already. But COVID has completely upended the legislative framework and the landscape that we've got to look at. The basic points are these, and I'm going to take this all at an incredibly high level, given the time that we've got available. This is one of those times where specialist advice from Beth, David, and dare I say it, even me, is available offline if you've got a specific problem. But the basic points are these. Statutory demands served at any time effectively from about March this year cannot form the basis of a winding up petition presented at any point after the 27th of April. So the main tool for getting insolvency procedures up and running, leaving aside things like administration and moratoria, things like that, is currently in abeyance. There's just a blanket ban. From about the 27th of April, there are some limited exceptions to that. And basically the rule is you can only get a winding up petition going in respect of a debtor if you can show that the debtor would have been unable to pay, even COVID notwithstanding. That's the basic rule. Going along with that is the current moratorium, as David has mentioned, on Section 214 of the Insolvency Act 1986, wrongful trading, as it's often called, although those words aren't actually used in the statutory definition. And in normal times, that's a pretty powerful stick that the court holds by its side to deal with directors who might otherwise be tempted to trade whilst they're insolvent. In normal times, directors have to take every step from what's sometimes called the moment of truth, when they should have realized that the company should stop trading. They have to take every step to minimize the loss of assets to the creditors. on pain of having to make a personal contribution to the deficit in the winding up in due course if they don't take all those steps. So very important in normal circumstances, speak to people like Beth and David to show that you've taken a sensible course that the reasonably competent director would have taken in your position. But at the moment, that's gone. In the moment, that's completely suspended. If people are tempted to take their C-bills loan or their overdraft and spend it all on a Porsche or put it all on red at Monte Carlo, I'm afraid I've got bad news for you. Although Section 214 in the Insolvency Act and wrongful trading is currently in abeyance, all the other duties that tend to go along with that are still very much alive and well. For example, the prohibition on fraudulent trading under Section 212, that's still there. The rules against misfeasance, which apply, directors' duties, they're all still there, still got a duty to act in the interest of the shareholders. And if the company is verging on insolvency, an obligation to act in the interest of the creditors as well. And directors' disqualification is still there with penalties, bans and fines for directors who fail to comply with their statutory and common law duties. So it's all very much changed in a lot of respects, and the conventional insolvency procedures that you would see follow aren't available, or certainly are only available on very much more limited terms. But a lot of the other weapons that the courts have around to police insolvent companies and their directors, they're still very much there.
Good. And occasionally, when disputes go to court and an award is made in favour of one party or another, and the losing party is insolvent, what options are available to parties for obtaining payment in such situations?
I think it's important to distinguish between insolvency and enforcement, because they're two different things. Enforcement is what happens with the judgment. Insolvency is what happens if you can't enforce. Just to go right back to the beginning to what David said at the start, is the statutory definition of inability to pay means just that. The court has to be satisfied you cannot pay your debts as they fall due. Obviously, if there is enforcement and it comes back unsatisfied, that is one of the grounds for Section 123 and the definition of inability to pay being satisfied, unsatisfied execution. In what people tend to do is they tend to skip enforcement and go straight to insolvency. So when they get a judgment, they will say you're obliged to pay this within 14 days. If you don't pay it within 14 days, a winding up petition will follow, in the hope that they don't need to go around and enforce against your assets, because the threat of winding up will force you to essentially self-liquidate enough assets to meet your judgment. But assuming that that doesn't happen, and you've got to go around and enforce, there's a whole suite of powers in the civil procedure rules and indeed in the insolvency legislation to assist with that. You can, for example, seek third-party debt orders over third-party bank accounts to get monies redirected from the company's debtors to you to pay your judgment. You can get charging orders over any real property that they've got, and obviously a charge ranks in priority if they do ultimately go bust. And more thinking just slightly more laterally about these kinds of problems, if the problem is not a can't pay situation, but a won't pay situation, where the debtor is moving money out of the company to the directors or to associated companies in order to frustrate enforcement, you can get post-judgment freezing orders, which will freeze any assets, including assets in the hands of third parties. And as an absolute last resort, the insolvency court's nuclear weapon is the appointment of a provisional liquidator. And that is someone who comes in and is an officer of the court and takes control of the company for the benefit of all of its creditors, including the judgment creditor in these circumstances, because the court is satisfied that there's strong evidence of a real risk of dissipation if the directors are left in charge. So insolvency and enforcement are different things. Theoretically, you should do enforcement first and then move to insolvency if you can't enforce. That rule is normally observed in its breach. But if you can't enforce, you move to insolvency, and then you have to speak to someone like David. And if you're a director, you should speak to someone like Beth. Brilliant.
Thank you. And so finally, just in the last few minutes, obviously there's the recent cases in adjudication around insolvency, Bresco being the one that's been written about lots, but there have been a few more recently. Do you think that case, the Bresco case, will have a significant impact, or is it indeed, in light of the more recent cases, having a significant impact? And can you tell us a little bit more about this kind of tension or conflict between the Insolvency Act and the Construction Act, if there is one?
That's always been there, because the Construction Act espouses a sort of pay now, argue later philosophy, whereas the Insolvency Act has always said you can't make someone bankrupt or wind them up, in the case of a company, unless and until all disputes on both sides of the line have been dealt with. So that there's always been that latent conflict between them. And the general rule is that if push came to shove, the insolvency provisions won, for want of a better phrase, because you can't, once a company's been wound up, it's wound up, and therefore if you have to choose which act trumps the other one, then the Insolvency Act wins. The Bresco decision, again, everything's been turned upside down. This time, the legislation's been turned upside down by COVID, and the conventional wisdom on the use of adjudication for insolvent companies has been turned upside down by Bresco. The two don't have anything to do with each other, but they do mean that the landscape now looks very different. The conventional wisdom in a long line of cases pre-Bresco in the Supreme Court, including in the Court of Appeal, was that insolvency of one of the parties created self-executing insolvency set-off. There was therefore only one debt due to or from the company, and therefore adjudication over individual disputes simply wasn't available. I'm paraphrasing hugely, but that was what was said in some of the earlier cases. And so the received wisdom at the bar, I was guilty of it, and many others were too, is that once the one party is in a form of insolvency, including administration for these purposes, adjudication was just not available to you. That's all changed. Bresco tells you that's wrong. Bresco tells you that adjudication is available. And Bresco also told you in the Supreme Court that not only is it available, but that the TCC shouldn't be restraining liquidators and administrators from going to adjudication because it's not futile. There's a futility argument. And then the Supreme Court said, in rather sweeping terms, it seems to me, well, the TCC can just work out on enforcement what it wants to do with these decisions for or against liquidators, particularly decisions for liquidators. And that can just be worked out at the enforcement stage. We've had a couple of cases on that, and the most recent one, and the only one I really need to touch on for these purposes, because of time available, is the decision of Mr. Justice Fraser in John Doyle and Erith. And in essence, what happened there is that the claiming party seeking to enforce a decision, relying on Bresco, saying we are insolvent, but nonetheless we are entitled to enforce, see Bresco, asked for the adjudicator's decision to be paid. And the responding party didn't like the sound of that very much, because it said, but what if we get a different determination on a final determination from the TCC? There'll be no prospect of the money being paid back. And what Mr. Justice Fraser said is that there are 5 relevant principles that will be applied now by the TCC to decide whether or not to enforce a decision in favour of an insolvent party. And I'm just going to rattle through them very quickly. The first is that adjudication enforcement in favour of an insolvent party will only go, if I can put it like that, if it deals with the whole of the dispute between the parties. So it's only going to be available for final account disputes, termination account, final account disputes. And secondly, are there other disputes outside the construction sphere which the adjudicator couldn't deal with? And if there are those disputes, the court will have to look at those on enforcement too. I wonder in practice how relevant that second consideration will be, because of course, any defence in law which is available to a party can and should be run in the adjudication. It'd be a relatively unusual set of facts where there was a separate dispute which couldn't be run as a defence. It would have to not be available as a set-off. And in my experience, invariably things can be run as set-offs, save in relatively unusual circumstances, separate projects, for example. Thirdly, were any of the defences available to the claim not available in the adjudication? And that seems to me, and I'm paraphrasing Mr. Justice Fraser, who says the same, to probably overlap with the second consideration. They're not really, they're probably just different ways of saying the same thing. And then this is important. Let's assume you overcome all those hurdles. You've got a final account dispute. It deals with all the issues between the parties. Then and only then the court may enforce if the liquidator or administrator can give sufficient guarantees to the court that if it loses at the final stage, court dispute goes on to the TCC, it will be able to repay the money. And what will have to be given is some form of security, a bond for repayment, or a ring fencing of the monies, both of which were discussed in that case. And that's not just set up, that will have that bond or that ring fencing will have to cover not only repayment of the money that's been ordered over, but also any counterclaims that might be available that the adjudicator can otherwise deal with, and possibly also security for costs, which is something which he didn't ultimately have to go into given the other findings he'd made. But he said there's also a secondary consideration, which is, will the party receiving the money be able to give security for costs of the other party chasing him down in court to get it back? So in practical terms, Erith seems to lay down a marker that the TCC will only enforce final account claims where there can be given sufficient assurances that the money will be able to be paid back if it's ordered to be paid over. If you were looking for it in 2 lines, it seems to me to be that. Lots of other things not yet decided in Erith. Would the losing party have to undertake to commence proceedings to get the money back? Would it have to give that undertaking? If the money was paid over, it seems to me to be that if you say that the liquidator should ring fence the money until you bring a claim to get it back, you ought to get on with that claim. One can see a circumstance where that might be a price that a party has to pay in order to get the ring fencing ordered by the court or get the bond ordered by the court. So plenty yet to be worked out after Bresco and John Doyle Erith. There's more to come on this, but it does seem to me that the court is laying down a firm marker that the Bresco principles are going to be put in place, but with practical requirements, meaning that there's got to be a way of getting the money back at the end of the game.
Brilliant. Thank you very much, James. Thank you all very much for attending. Thanks to everyone for coming along and listening. As I say, next time we'll be discussing not insolvency, that's what we did today. Next time we'll be discussing CSR, corporate social responsibility strategy, why it's good for business, how it can help your business grow. Do join us if you can. The details are on our website. And thank you to our speakers, to David, to Beth, and to James. And we'll hopefully see you again very soon. Thank you.
Okay, thank you.
Thank you all very much.
Thanks very much.